our position in relation to the new document that my learned friend has referred to up front, and then deal with the three issues that we propose to deal with in reply. My Lord, it is entirely inappropriate and obviously inadmissible to simply upload a document not attached to any affidavit. We have no idea of its provenance, who created it. It appears to have been created, my Lord, during the course of the hearing yesterday and attached as some sort of putative response to the concerns around the non-payment of over 1 million grant beneficiaries a month. It is obviously inadmissible, my Lord. Your Lordship has heard submissions on it, and to the extent necessary, we'll address its content. It takes matters no further. If anything, it simply reinforces the need for a proper investigation by SASSA and DSD into the problems of non-payment and an appropriate report to court on what is being done to remedy the egregious violations of the rights of those beneficiaries. But, my Lord, we propose to deal with only three issues in reply, three themes. The first is the issue of abdication. Abdication and usurpation. The second is the issue of affordability. And the third, the question of accountability and an appropriate remedy. So we'll address abdication, affordability, and accountability. On the question of abdication, my Lord, and its accompanying twin of usurpation, we're concerned with the roles of the relative respondents. As the primary respondent, the Minister of Social Development and SASSA, my Lord, had the responsibility to address the issues in this matter. The Minister of Social Development is the minister responsible for administering the Social Assistance Act. She makes the regulations in terms of that act, the regulations that are the primary subject of this hearing. SASSA bears responsibility for the implementation of those regulations. And Lord, these two respondents accordingly have the particular knowledge of the problems, the facts, the justifications, any attempted fixes. They have the knowledge. They also, my Lord, have the constitutional responsibility to address these matters. And what your Lordship has seen in this application to date is an abdication of that responsibility. An abdication that has arisen in the context where National Treasury, which has stepped into that void, has, in the words of the Department of Social Development, unfavorable views towards the social relief of distress grant. My Lord, notwithstanding having dealt with this in our main submissions, there are echoes still of a refrain that the grant is temporary, without reference to any evidence, without reference to any public statement or official position by any of the respondents, evidence from the bar. And so it is necessary, my Lord, for me to refer to three of the statements, public statements by the key relevant officials in this matter. Your Lordship indicated yesterday that your Lordship had read these statements. We emphasize only three of them. There are more than 10. It exceeds 20. The first one, my Lord, is the statement of the President in the 2024 SONA, which appears in the replying affidavit at paragraph 6. My Lord, that is 011-8. (011-8) at paragraph 6 of the replying affidavit. My Lord, this is the most recent statement by the most senior member of government, the head of the national executive and the head of state, at the most solemn occasion of state, the State of the Nation address, this year in 2024. And there the president said, in the midst of the pandemic, we introduced the special social relief of distress grant, which currently reaches some 9 million unemployed people every month. We know it's a little less than that, my Lord. The president continues, we have seen the benefits of this grant and will extend it and improve it as the next step towards income support for the unemployed. That is the president in the State of the Nation address. The next to which we would refer your lordship is a statement by the Department of Social Development itself, and this appears in Annexure RA9 at 011-256. My Lord, it's 259 where RA9 begins. Sorry, my Lord, you bear with me. I'm just looking for the. Beg your pardon, my Lord. The relevant part of the text appears at 011-260. My Lord, this is a briefing by the department to Parliament, to the Portfolio Committee on Social Development. It begins on 259, the cover page, and then the relevant text is on 260. May 2023, briefing by the department to the Parliamentary Portfolio Committee on Social Development. And again, my Lord, we need to hardly emphasize that there could be few less formal occasions than the department briefing Parliament through the Parliamentary Portfolio Committee. My Lord, the relevant text, it's bulleted, but it is the sixth bullet. And the heading is Status of the MTSF Targets against the Executive Performance Agreement. And the sixth bullet, my Lord, which begins Policy on Coverage for 18 to 59. And it reads, my Lord, government must view the SRD grant of 350 Rand as not just a temporary measure, but a precursor to a permanent income support policy for the working age population. Explicit in the department's own words, my Lord, not just a temporary measure. And my Lord, the third statement to which we refer your Lordship is perhaps the most recent. It's a statement of the Minister of Finance. And it appears, my Lord, at RA2. Page 011-153. 011153, it's Annexure RA2 to the replying affidavit. My Lord, this is a government news media release arising from the Minister of Finance, Minister Godongwana, and it's headed Godongwana announces increase in 350 Rand grant. It's dated March 14th, 2024, It was on this date, my Lord, that the Minister announced that the 20 Rand increase would be implemented. The actual increase followed in April when amendment regulations were issued. But this is the announcement attributed to the Minister of Finance, the third respondent. And it begins, my Lord, in the first two paragraphs by noting that the SRD grant will be increased from 350 Rand to 370 Rand from April of 2024, and that this was announced by the Minister in the National Assembly the previous day, the Wednesday, March the 13th. And my Lord, there are two relevant, the next two paragraphs are the relevant paragraphs. First, the Minister is quoted, the Minister of Finance is quoted as saying, His Excellency the President, in his State of the Nation address, said the SRD grant is going to continue and the 350 Rand will be improved. My colleague, the Minister of Social Development, is going to publish for comments a comprehensive social security program, and that will define a better platform and a future for the social security net in South Africa. And then crucially, my Lord, the next paragraph, again quoting the Minister. I am pleased to say that we have found consensus that in between, subject to the finalization of the comprehensive social security program, we'll increase the 350 to 370 Rand by the 1st of April this year. And we emphasize the next part, my Lord, that is part of the progressive realization of the basic rights of our people. So the Minister of Finance in public announces the increase and says, this is what government is doing pursuant to the President's State of the Nation statements to progressively realize the right. We now hear again, my Lord, echoes of, well, the grant is still temporary. So the question, my Lord, is the government progressively realizing it? Treasury argued that they have, or is it temporary? My Lord, those are the three key public statements. They are repeated consistently by all of the same entities and other officials across various formal spaces over the last 2 years. My Lord, the next reference that we need to provide, I alluded to this, but I must take you to the detail. It again goes to the relationship between the respondents. And it's at RA6, page 011-244. My Lord, this document begins on page 011-235, and it is a progress report by the Department of Social Development, dated 24 July 2023. And the relevant part, my Lord, to which we would refer your Lordship, is at page 244, 011-244. Headed Proposals for SRD Grant for 2024-25, the current year, to 25-26. My Lord, it sets out the proposals of the department itself. And the first bullet refers to the current budget allocation. The second bullet, my Lord, on that page reads, the current amount of 350 Rand has not been adjusted to keep pace with inflation since the introduction of the grant in 2020. In real terms, this implies a decrease in the grant value individuals are receiving of around 16%. Increasing the grant to 500 Rand or 663 Rand would have a significant effect on poverty. And my Lord, the department continues in the next bullet, proposing the extension of the grant until the end of 2025-26, at the least, at the end of the financial year that will begin next year, my Lord. But then crucially, in the final bullet, the department recommends the following: extending the allocation of the SRD grant for the next 2 financial years, increasing the amount of the grant from 350 Rand, increasing the current means test threshold from 624 Rand. My Lord, the department's own proposal in July of last year, which makes their stance in the litigation their silence, their abdication, really quite difficult to comprehend. But that is the Department of Social Development itself, my Lord. My Lord, we've made the submission that the applicants in this matter seek not to overturn government policy or replace it with their own wishes, but to enforce what government policy actually is and to hold the regulations to the Constitution. My Lord, in the circumstances, what ought to have been expected of DSD is to explain those public statements, which are all admitted, and to assist this court to find constructive solutions through the relief to realize the constitutional right of social assistance, which is what the department, behind the scenes and in public, seeks to do. So much for the department, my Lord. We submit that they have fallen short of what is required of them constitutionally in the conduct of these proceedings, and we make that submission advisedly. I turn now to National Treasury, my Lord, where we've seen an evolving stance. Initially, my Lord, in its answering papers, and indeed in the heads, Treasury said nothing on the appeal issue. Consistent with that, Treasury has conceded that attack on the appeal regulation. But in relation to bank and database verification, my Lord, Treasury's initial position in the answering affidavit was that the implementation of these systems is within the knowledge of SASSA and DSD and not for Treasury to speak to. Now, in the course of the hearing, we see Treasury stepping up to seek to defend those systems. In relation to the non-payment issue, my Lord, Treasury was consistent. It said this is an issue for DSD and SASSA outside our knowledge, and they have not sought to speak to the issue. But what they have sought to do, my Lord, is generally to defend the 6 exclusionary regulations that we challenge. They've stepped into the role that ought to be played by DSD and SASSA, who administer those laws, the minister who makes those regulations, and Treasury has offered attempts to defend those. And we've made the submission, my Lord, that those relate to the substantive policy and the administration and implementation roles of the department and SASSA. And the concern, my Lord, is that what we're seeing is National Treasury, which is undoubtedly an effective organ of state, stepping into this void, raising the spectre, my Lord, of an imperial treasury that runs every section of government, and of replacing, my Lord, and I'll turn to this in a moment, our system of constitutional supremacy with one of fiscal supremacy. And it's to that issue that I now turn, my Lord. The second issue that we address in reply, which is affordability. On affordability, my Lord, we must be very clear that Treasury does have a legitimate role to play. Its concurrence is required. Its role is focused on the question of affordability and the resourcing of the grant provision. Where it steps outside its role, my Lord, is where it deals with issues of the administration of the grant, how decisions are made, how applications are received, the system, its implementation, those issues, and the substantive policy, my Lord, the future of the SRD grant. It has a voice in government on those issues, in cabinet. but the primary responsibility for those policy issues rests with the department, appropriately so. Lord, we turn then to the issue of affordability. And on affordability, we have simply two legal authorities to refer to. They're not new. We simply highlight. And two factual issues and a final submission. The first authority to which we'd refer, Your Lordship, and it's quoted in our heads, but we didn't previously emphasize it, and my learned friend raised the case in his argument, and that's Blue Moonlight, my Lord. It appears in our abridged authorities bundle at page 62, the relevant page. The case lines reference, my Lord, is 021-397. And it's paragraph 74, my Lord, of the Blue Moonlight decision of the Constitutional Court. And it deals with this question, my Lord, of whether the absence of a budget allocation or budget constraints can be relied upon. And we emphasize that it's been repeatedly cited by the courts subsequently. My Lord, the Constitutional Court held as follows: the city provided information relating specifically to its housing budget, but did not provide information relating to its budget situation in general. We do not know exactly what the city's overall financial position is. This court's determination of the reasonableness of measures within available resources cannot be restricted by budgetary and other decisions that may well have resulted from a mistaken understanding of constitutional or statutory obligations. And that's the key sentence, my Lord. The court continues, in other words, it is not good enough for the city to state that it has not budgeted for something, if it should indeed have planned and budgeted for it in the fulfillment of its obligations. So, my Lord, the Constitutional Court makes the simple point that the constitutional obligations come first and budgeting follows. Treasury has sought to invert that process by trying to define the obligations from the beginning by reference to budgetary constraints. And if, my Lord, the state has misunderstood its constitutional obligation, in particular to progressively realize the right, that would fall squarely within the Blue Moonlight dictum. The second authority to which we'd refer, Your Lordship, is again Justice Mokgoro's judgment in Kosa. My Lord, the relevant paragraph appears at page 103 of our abridged hard copy bundle, and in case lines at 023-373. And it's paragraph 62. (023-373). And it's the Constitutional Court decision in Kosa, paragraph 62. 373, my Lord. (62, my Lord). My Lord, there's already been repeated reference to Kosa. It was concerned with the exclusion of permanent residents from the Social Assistance Act. And in passing, my Lord, I mentioned that the remedy that the court adopted was to read in the words "or permanent residents." So it is a good example of an appropriate reading in directly on point. But for present purposes, I'm concerned with Justice Mokgoro's approach to the budget evidence that was put up in this matter, which was a little bit different from Blue Moonlight. And Justice Mokgoro held as follows at paragraph 62. There is thus no clear evidence to show what the additional cost of providing social grants to aged and disabled permanent residents would be. Taking into account certain assumptions relating to the composition of the groups and numbers of dependents, Mr. Kruger, one of the deponents, concludes that the additional annual cost of including permanent residents in grants in terms of sections 3, 4, and 4B could range between 243 million and 672 million. The possible range demonstrates the speculative nature of the calculations. My Lord, I pause to note that Treasury has similarly put up a range. They've identified a range of potential costs arising from different aspects of the relief. The court continues, the possible range demonstrates that the speculative nature of the calculations, but even if they are taken as providing the best guide of what the cost may be, they do not support the contention that there will be a huge cost in making provision for permanent residents. Approximately 1/5 of the projected expenditures in respect of child grants and the unconstitutionality of the citizenship requirement in that section of the Act has already been conceded by the respondents. But this is the important part, my Lord, that we intend to draw on. The remainder reflects an increase of less than 2% on the present cost of social grants. Currently 26.2 billion, even on the higher estimate. Bearing in mind that it is anticipated that the expenditure on grants will in any event increase by a further 18.4 billion over the next 3 years without making provision for permanent residents, the cost of including permanent residents in the system will be only a small proportion of the total cost. My Lord, what the judgment demonstrates is, first of all, that courts should not be afraid to analyze and engage with the budget numbers that have been put up. And to the relevant comparators, my Lord, are what is the current budget for social assistance? That is the 26.2 billion that Justice Mokgoro refers to. That's the total budget. It's hard to think, my Lord, that 20 years ago it was 26.2 billion. It is today 250 billion. And she finds that the relief sought within the range that has been estimated by the state will be about 2% of the total cost of all social grants. And she holds that is not the huge, terrifying increase sufficient to provide a basis not to grant any relief. My Lord, the first exercise, which is quite a straightforward one, is simply to look at, rather than the large figures, the large general figures that Treasury was throwing, the specific figures relating to social grants, the SRD, and the possible increases that would flow from the relief. And my Lord, the total budget, as my learned friend indicated, for social assistance is currently approximately 250 billion rand per year. Will increase next year. The SRD grant budget is around 30 billion currently. It's been cut and slashed over the last 4 years from the 44.4 billion down to approximately 30 billion currently. That 30 billion is about 8% of the total social assistance budget. So it's just a portion of it. And all of the other grants, child support, disability, war veterans, pension, and so on, make up the other 92%. So we have total social assistance budget, 250 billion. SRD grants, 30 billion, it's about 8%. This year's increase, my Lord, the 20 Rand increase, that, if multiplied by approximately 8 million beneficiaries, cost the state around 2 billion Rand, just under 2 billion Rand. That was the additional cost arising from that increase. To all of us laypersons, my Lord, outside the sphere of the national budget, that sounds an enormous figure. But that 2 billion Rand, my Lord, is less than 1% of the budget for social assistance in the year. So it's about putting it in perspective. And my Lord, your Lordship had regard to Justice Mohoro's finding that the increase flowing from adding permanent residents into the system of around 2% of the total social assistance budget was not considered, in her language, so huge as to be a basis not to grant that relief. Now, my Lord, there is a measure of speculation involved, but we've made the submission that your Lordship does not need to determine exactly what the cost of the relief will be. What we can see, my Lord, is that an increase this year cost approximately 2 billion. That was about a 1% increase on the budget. So the sorts of increases that we're looking at are in that range, my Lord, realistically. Treasury points to an upper speculative figure that if the grant value was doubled and the number of beneficiaries was doubled, then of course the cost would also be doubled. Then it would be more like 2% or perhaps 4% of the total social assistance budget. But my Lord, understanding it in that perspective gives a proper sense of scale of what we're dealing with here in terms of the increases. Which is lost if those percentages are not determined along the way. And my Lord, on the subject of scale, the SRD grant, in its overall cost implications, is similar in scale to the other grants that are administered. It's not as if it is the grant that makes up 90% of the social assistance budget, squeezing out the other grants. In fact, the contrary. It's only 8% of the social assistance budget. The child support grant has 13 million beneficiaries and is higher in value. So, my Lord, again, a sense of scale in terms of the impact of the relief that's sought. It's not something so ruinous as has been suggested. My Lord, those are the factual submissions. There's one final legal submission that I must make in relation to affordability. And it goes to the paradigm, my Lord. What frame, what set of values informs this consideration of affordability? And your Lordship will have had regard to the analogy put up by National Treasury of a seminar being planned and how many notebooks to buy for the attendees who are expected to attend that seminar. That there are 200 possible attendees, but in previous years, generally the attendance has been less than the full 200 staff members. And so it's entirely appropriate for the organizer of that seminar to only budget for and buy 100 notebooks, given last year's attendance. And my Lord, we submit that that analogy is telling. It reveals that Treasury is approaching the questions of affordability in this matter as if they're a technical, arithmetical, bureaucratic exercise that one might find in a corporate setting. And we responded in reply, my Lord, that the analogy is entirely inapt in a context where the SRD grant is all about hunger. It is about lifting people out of hunger. The 20% of our population who currently live in hunger, below the food poverty line. The 20% of our population who routinely send a family member to beg for food. And so, my Lord, we submit that when approaching questions of affordability, the starting point is to recognize that these are not seminar attendees who may benefit from having a nicely covered notebook, but they are constitutional rights bearers. And that, my Lord, all of Treasury's powers are derived from the Constitution. The Constitution governs Treasury's powers to generate revenue, to allocate resources. So the paradigm, my Lord, is the Constitution, and in particular, the Bill of Rights. Budgeting is not some technical exercise in mathematics, not as an exercise of public power, my lord. It is one of the most profound constitutional powers conferred by our Constitution. And every constitutional power exercised by an organ of state is subject to the Bill of Rights. Section 7.2 of the Constitution requires every organ of state in the performance of all of its powers to respect, protect, promote, and fulfill the rights in the Bill of Rights. My lord, the final point I must make on affordability, and that will take me to the third and last of the issues that we address, is that affordability is in any event no answer to any of the exclusionary regulations. It doesn't help to interpret the regulations, and it's no answer to the other exclusionary regulations. It really goes to the questions of the grant value and income threshold. And we have shown, my lord, that the relief sought does not pose the sorts of affordability concerns that would constitute a basis not to grant it. My lord, we turn then to the final issue that we address, and that's the question of accountability and the relief sought. My lord, the general approach of the respondents, at odds with what we called for at the commencement of this hearing, has been to seek to avoid constitutional scrutiny and judicial intervention in relation to the problems with the regulations. Problems of massive proportions that affect millions of the most vulnerable members of our society. Two days on, my lord, and now into the sunset of this hearing, the position that we've reached is a concession that the appeal regulation, barring new evidence on appeal, falls to be struck, and an argument, my lord, carried through on each of the other regulations that, well, those problems can be fixed by appealing. And we submit, my lord, that that is not so for two principal reasons. The first, my lord, and this was effectively confirmed by my learned friend for the first and second respondents, is that it is simply impractical to expect millions of wrong decisions to now be corrected on appeal involving new evidence. So we already have seen over 1 million appeals a month. The suggestion is that that would be expanded. There would be even more appeals now with new evidence. And my learned friend is correct to point out that it will require more time then to decide each of those appeals. So although we make the submission that the fix to the appeal regulation is absolutely necessary, it's not the answer, my lord. And we will then likely be faced with massive delays in millions of appeals. So there's an impracticality problem, my lord, which is profound. But there is a second reason why allowing wide appeal doesn't fix the other problems. And it's an issue of principle, my lord, and of the rule of law. Which is, my lord, that it is wrong as a matter of principle to knowingly subject grant applicants to rights violations in their millions and say to them, well, it will be left to be fixed on appeal. And it will be your responsibility to do that. So, my lord, the appeal relief, though important, and though it will make some difference, doesn't solve the other problems, which are systemic. The respondent's position, my lord, is give no relief in relation to any of the other problems. And we called upon them yesterday, my lord, to suggest alternative framings, to suggest alternative language, to put up draft orders. They've declined to do so. And my Lord, in that regard, we would refer briefly to the Mazibuko judgment. At page 136 of our bundle, and the case lines reference, my Lord, is 021-895. My Lord, we took your Lordship to Mazibuko yesterday, and we referred your Lordship to paragraph 162 on the approach to reasonableness and the requirement not to be rigid, not to be set in stone. We now need to refer your Lordship to the paragraphs immediately before and after that, paragraphs 161 and 163, which are concerned with the issue of accountability and the role of litigation of this sort in achieving that sort of accountability. In paragraph 161, my Lord, Justice O'Regan held, when challenged as to its policies relating to social and economic rights, the government agency must explain why the policy is reasonable. Government must disclose what it has done to formulate the policy, its investigation and research, the alternatives considered, and the reasons why the option underlying the policy was selected. The Constitution does not require government to be held to an impossible standard of perfection. My learned friend referred to this. Nor does it require courts to take over the tasks that in a democracy should properly be reserved for the democratic arms of government. Simply put, through the institution of the courts, government can be called upon to account to citizens for its decisions. This understanding of social and economic rights litigation accords with the founding values of our Constitution, and in particular, the principles that government should be responsive, accountable, and open. My Lord, we took you to paragraph 162 yesterday. That's about not being rigid, the need to continually review, don't be set in stone. But the court continued in paragraph 163. This case illustrates how litigation concerning social and economic rights can exact a detailed accounting from government, and in doing so, impact beneficially on the policymaking process. The applicants, in argument, rued the fact that the city had continually amended its policies during the course of the litigation. In fact, that consequence of the litigation, if such it was beneficial. Having to explain why the pre-basic water policy was reasonable shone a bright, cold light on the policy that undoubtedly revealed flaws. The continual revision of the policy in the ensuing years has improved the policy in a manner entirely consistent with an obligation of progressive realization. My Lord, in sharp contrast to the current matter, where since the instigation of the application, the only change that has happened is the belated 20 Rand increase. Every other issue relating to the mass exclusions, the problems with the databases, we simply have received a stonewall, exactly what the Constitutional Court in Mazibuko indicated is not constitutionally permissible. An approach set in stone that says also to this court today, grant none of that other relief. In Mazibuko, the city had taken heed of the concerns raised by the applicants, residents of Piri and Soweto, and incrementally improved, so that by the time the Constitutional Court heard the matter, it held that the infirmities had been remedied. Would that it were so in the present matter, my Lord. And it's as a result of that stonewall approach, my Lord, that it remains necessary with respect for appropriate relief to flow in relation to each of the issues raised by the applicants. And my Lord, on most of them, there's very little that I need to say in reply. On the definitions of the terms, your Lordship is unfortunately left in a difficult position that an alternative meaning has not even been suggested by the respondents. You were told to reject the interpretations advanced by the applicants, but it seems to us to be logically impossible to do so without saying that the terms mean something else. So we're left to ask, what do these terms of income and financial support mean? and we stand by the carefully constructed definitions that we have identified. We've noted that the respondents accept that at least CSG grant payments and money held on behalf of others need to be excised from the interpretation, but we also propose the other elements. We stand by those definitions. My Lord, in relation to the online-only issue, we submit that no serious answer has been offered to the problem of the people who are excluded, other than that they are Yamachafala, my Lord. The term derived from the Van Heerden matter. My Lord, Van Heerden was concerned with old order parliamentarians, members of the pre-democratic parliament, and their pension benefits. He was concerned with 145 of them who didn't benefit from transitional laws at the turn of our democracy. My Lord, to compare 145 old order parliamentarians to millions of grant beneficiaries living below the food poverty line is with respect inappropriate, both in scale and in substance. Something is required to address the rights of those who are likely to be the very most vulnerable of the eligible grant beneficiaries, those who do not even have a smartphone. And with respect, my Lord, it's no answer to suggest now from the bar that they can approach their chief, if in rural areas, presumably to ask to borrow the chief's smartphone. My Lord, a systemic response is required. SASSA has officers that administer all of the other social grants. That then for the online-only issue. In terms of the database and bank issue, my Lord, the high watermark now of the defense on those is that these issues can be fixed on appeal. And your Lordship saw the evidence that at least one of the databases or the labor-related databases have an up to 35% error rate, accounting for the majority of false exclusions. And your Lordship saw that up to 40% of applications are rejected each month. And a large proportion of those wrongly as conceded by the respondents. It is no answer to those for the reasons I've already given to say it can be fixed on appeal. That each of those people can appeal and attach a letter from UIF, a letter from NESFAS, and so on. Yes, they should be able to do so, but something needs to be done, my Lord, about the endemic problems with the databases. And the constitutional responsibility to do so, my Lord, rests with the department and SASSA. And in that regard, my Lord, we've suggested a period of 6 months in our alternative relief. We recognize that it's a difficult task. We've suggested 6 months to fix it. The last of these exclusionary issues, my Lord, in that category is the budget cap. And again, my Lord, with respect, your Lordship heard little argument why it is not arbitrary to say to a successful applicant, 8,000,001, that the money has run out. Why is that not arbitrary? The defense that remained was that they say it's never happened, my Lord, but what we know is, there are two answers to that, my Lord. One is legal, one is factual. The legal answer, my Lord, is that in terms of Section 38 of the Constitution, if a right in the Bill of Rights is threatened, that is a basis to grant effective relief. In fact, the courts have a duty to do so. So we don't have to wait for that unhappy circumstance, my Lord. But the second answer is a factual one, my Lord. We know that Treasury's whole approach has been to bring the budget down to try and get closer and closer each year to the actual number of approved beneficiaries. So they are targeting that goal. They want that line to be reached. And so it becomes a realistic probability. My Lord, they also offer no benefit. They don't say that they say it's speculative, it hasn't arisen, but they don't say they need this regulation to serve any important purpose. So, my Lord, so much for that budget cap regulation. That leaves, my Lord, the issues of the value and the threshold, and then finally the issue of non-payment. In relation to the value and the threshold, my Lord, my learned friend, Mr. Marcus for National Treasury, was at pains to emphasize that government has a range of plans to deal with poverty, dealing with job creation, electricity generation, and a range of other matters. All we roundly accept, my Lord, that these are all important matters. But, my Lord, they're entirely irrelevant to the question of what is the government's plan for the grant value and the income threshold. It is no answer to say that we have long-term generational plans to reduce poverty and create jobs. The constitutional obligation of the state, my Lord, is to have a plan. That's the at a bare minimum, my Lord, just to have a plan around the grant value and the threshold. And I took your Lordship to the statements from the President, the Department, and the Minister of Finance that say the grant is to be retained for at least the next 2 years. It is to be extended and improved. So that's the public stance. But what is the detail of that plan? And why are the respondents not willing, as required by Mazibuko, to place that plan before the court and to say the plan is to increase the grant value by 1%, by 4%, by 10% next year? My Lord, National Treasury made the submission that there has been progressive realization of the SRD grant, and they said so for 3 reasons. They said the establishment of the grant itself was progressive realization. Raising the threshold to the current 624 Rand in 2022 was progressive realization, and increasing the grant this year by 20 Rand, the grant value by 20 Rand to 370 Rand was progressive realization. That is their case, my Lord, on the steps the government has taken to progressively realize. And we submit, my Lord, that that is no answer to a challenge to the failure to progressively realize the grant value and the threshold. The first change that they rely on, my Lord, is the establishment of the grant itself. Well, that may be so, my Lord, but that's not the issue in this case. That was 4 years ago, and the case is they've failed since then to progressively realize. There's been a retrogression. And the other 2 changes that they rely on, my Lord, were both prompted by litigation. The income threshold was only raised to 624 Rand as a settlement following the Black Sash application. And the 20 Rand increase in the grant value followed this application. So we're in a situation, my Lord, where the only option available to grant beneficiaries is to litigate. And if they do so, after 2-3 years, there may be an uplift on one of either the threshold or the grant value. Absent that, no indication of a plan, no indication of any intention even to consider increases. And we submit, my Lord, that that falls short of the state's obligations to progressively realize the right, and indeed constitutes a retrogression. Things have moved backwards. My Lord, the question of inflation was raised, and with respect, our case in this regard was fundamentally mischaracterized. It was suggested to your Lordship that the nature of our case, the basis of it, is that there must be an inflationary increase every year of this grant and every other grant. That's our case, our demand. And that if such an inflationary increase is not granted, that will be automatically unconstitutional. That has never been our case, my Lord. Throughout the papers in argument, we have been very clear throughout, my Lord, that there has been a retrogression. That is what is unconstitutional. And that an increase over this 4-year period was required. But we have never said that that increase needs to be tied strictly to inflation or to the food poverty line. We have said that those are 2 crucial, relevant factors that government must consider when it decides on increases, as it does with all of the other social grants. And indeed, there have been sub-inflation increases, but there have been annual increases to every other grant. My Lord, it may well be justifiable, and we don't concede this, it doesn't need to be decided, but it may be justifiable to implement a sub-inflation increase next year. The ultimate test is reasonableness. And relevant to that will be the increase in inflation, the increase in the food poverty line, and indeed government's resources. They're all relevant factors. We've never said inflation is a bright line that has to be hit, or that the constitutional right is linked directly to inflation. What is not justifiable, we submit, my Lord, is to have allowed the grant value and the threshold to stagnate through these 4 years. To allow them to stagnate, to have no plan that is shared with the country, other than broad public statements committing to extending and improving the grant and progressively realizing it. And in this litigation, to refuse even to consider any increase or to consider adopting a plan. So, my Lord, we submit in all of those circumstances, a structural interdict is entirely appropriate. Government has fallen short of its obligations, and the department, in consultation with the Minister of Finance, must be directed to develop a plan relating to the grant value and the threshold. And my Lord, in relation to the appropriateness of the structural interdict, we would emphasize one further legal authority, and it's referred to in our heads of argument, but it is on point and appropriate. And it's the decision of the Constitutional Court in Mwelase. And it appears at case lines 021-1039. My Lord, as your Lordship is likely familiar, Mwelase was concerned with labor tenant claims, which in their thousands had not been processed or appropriately dealt with by government. And the Constitutional Court ultimately issued a structural interdict. And in doing so, my Lord, Justice Cameron, in what I believe was his final judgment, held as follows at paragraphs 48 and 49. And my Lord, this is cited in paragraph 270 of our heads of argument, where the court held as follows, my Lord. In cases that cry out for effective relief, tagging a function as administrative or executive, in contradistinction to judicial, though always important, need not always be decisive. For it is crises in governmental delivery, and not any judicial wish to exercise power, that has required the courts to explore the limits of separation of powers jurisprudence. When egregious infringements have occurred, the courts have had little choice in their duty to provide effective relief. That was so in Black Sash 1, a social grants case that we earlier referred to, and it is the case here. In both, the most vulnerable and most marginalized have suffered from the insufficiency of government delivery. And the court continues at paragraph 49, the vulnerability of those who suffer most from these failures underscores how important it is for courts to craft effective, just, and equitable remedies, as the Constitution requires them to do. In cases of extreme rights infringement, the ultimate boundary lies at court control of the remedial process. If this requires the temporary supervised oversight of administration, where the bureaucracy has been shown to be unable to perform, then there is little choice. It must be done. Here, the fact that the department's tardiness and inefficiency in making land reform and restitution real has triggered a constitutional near emergency, as explained earlier. This fact underscores the need for practically effective judicial intervention. And my Lord, we submit that the dicta in Mwelase apply with equal force to the current situation, which is one of egregious rights violations at scale, and if we borrow the phrase, a constitutional near emergency for the beneficiaries of the SRD grant. So, my Lord, we submit that the only effective relief in relation to the grant value and the income threshold is to make the declarator of unlawfulness and to direct government to come up with a plan in its own expertise. My learned friend for the National Treasury takes issue with the factors that we append to that part of the relief. which include taking into account the right in Section 27, the food poverty line, inflation, poverty and hunger. My Lord, we submit that those factors are obviously relevant, and it's hard to see how the plan could be developed without taking any of them into account. But if your Lordship were to find that it is somehow overly prescriptive to say take into account these factors, then a more open-ended order simply requiring government to develop a plan relating to the increase of the grant value and the income threshold, having regard to their constitutional obligations, ought also to serve the purpose. But we do submit that the factors are appropriate, they provide guidance, and we have made the concession, my Lord, that affordability is a relevant factor too. My Lord, the final aspect of the relief is the question of non-payments, and we'll be very brief here. My Lord, the document put up overnight without any affidavit is inadmissible. It's also relatively indecipherable with respect. On its own terms, it still reflects significant shortfalls in payment. And my Lord, as we understand the document, it is speaking now to whether late payments from 2 years ago were paid. And it says that even 5 or 6% of those from 2 years ago have still not been paid. So on its own terms, there's still a problem, if your Lordship is to take it into account. But my Lord, the document only goes up to April 2023. And as my learned friend, Mr. Mbikiwa, indicated in his submissions, my Lord, as late as September 2023, there were 1.2 million approved beneficiaries not paid. So after the dates in this document. But my Lord, if anything, what the document shows is that this is exactly the sort of investigation that the department and SASSA need to do. They need to identify the problems relating to non-payment and to develop a reasonable plan to remedy those. My Lord, those then are our submissions in relation to the relief in reply. In relation to costs, my Lord, it's necessary for me to make only one submission. The conduct of the department and SASSA in seeking costs against the applicants in this matter is at odds with all of our jurisprudence, and it is outrageous, my Lord. Those are our submissions, my Lord, unless there are any further questions. My Lord, there may, with respect, be one footnote to add just in relation to timing. And we do so with respect, acknowledging that this matter is one of complexity and depth and scale. But it's simply to enjoin your Lordship to see the urgency of this matter as it affects grant recipients. And my Lord, we make no hard or unreasonable asks in terms of the timing of delivery of judgment. And we cautiously and respectfully, my Lord, would make the request that if it is at all possible that judgment be delivered late this year or early next year, my Lord. That would be important because the current iteration of the regulations is due to be replaced, and the judgment would then inform the version of the regulations that is to follow. The urgency of the non-payments, my Lord, also speaks for itself. But my Lord, I've indicated that we make that request cautiously and with humility. As the court pleases, my Lord, we're indebted to your Lordship. If there are no further questions, my Lord, those are our submissions.